Well, the first proposition which I wanted to make was, a lot was asked on, is there a fundamental right to marry? And my submission in my first part of my note is that, if your lordship has got my note,
Yes.
the three cases, Puttaswamy, Shafin Jahan, then you have Navtej Johar, when they use the word right to marry, they really were meaning the right to cohabit, the right to live as a union. There was no concept of a marriage in the sense of the Hindu Marriage Act or the Special Marriage Act. Now, my lord, the same-sex marriage, I did some research. I could find it only in para 479 of Puttaswamy of Justice Nariman's judgment, where, if your lordship kindly sees at page 2, his lordship says rights of same-sex couples, including the right to marry. Lordship has got the bold, yes. Now, this is a bit ironical because this judgment was delivered 1 year before Navtej Johar. So at that time, it was an offense. So it could not be a fundamental right to marry. So, but anyway.
No, but in Puttaswamy, we had expressly cast doubt on the judgment which overturned Nas Foundation.
Correct, Nas Foundation, yes. So in that sense, yes, but I'm just saying that this was recognized. Now, please come to para 126, 167 of Navtej Johar, where then, my lord, the Chief Justice has set out what was the stand taken by the petitioners at that point of time. 1.3, lordship has got 1.3. The above authorities capture the essence of the right to privacy. There can be no doubt that an individual has a right to a union under Article 21 of the Constitution. When we say union, we do not mean the union of marriage, though marriage is a union. As a concept, union also means companionship in every sense of the word, be it physical, mental, sexual, or emotional. The LGBT community is seeking realization of the basic right to companionship, so long as such companionship is consensual, free from the vice of deceit, etc., etc. Now, my lord, what my submission is, when your lordship says there's a fundamental right to marry or a right to marry, your lordship is basically declaring a law, and I'm going to come to what is the status of a court declaring a right when I come to the sixth part of my submission. But now, once your lordship says, for example, in Navtej Johar, that you decriminalize a gay relationship, from that time onward, the law declared by the Supreme Court says that it's no longer a crime to have a same-sex union. And that's what it stops. Now, but to go one step further is a totally different aspect. Now, once the court says that a same-sex union is not illegal, is not a crime, from then on, any legislation cannot say that if two people of the same sex cohabit, it will be an offense. That's the law declared by the Supreme Court. Unless that law is changed by an amendment of the Constitution, that will be the mandate. And I give you examples where once your lordship declares the law, and lordship will kindly see Article 13(2) says law includes. It is not just Act of Parliament, notification, regulation, custom having the force of law. I would say a law by Parliament is X. The interpretation played by a lordship is Y. And X plus Y will become the law declared by Parliament in future. Now that can be changed as per Prithvi Cotton Mills by reviewing the basis of the judgment and so on. But once your lordship says that the fundamental right to marry, it is a recognition that they have a right to cohabit. It was not used in the sense of marriage as in the marriage law. That's the first proposition I'm making. Now, my lord, I've just given examples of how the Parliament has overcome judgments which it did not find, like, for example, whether in reservation cases or in 46th Amendment, etc. When Supreme Court said, yes, you can't levy tax on works contract, they made the 46th Amendment. When they said you can't cross 50% limit in promotion, they made it. EWS. It was said that economic criteria is not a criteria. Mandal said that. Indira Sawhney's case. But lordship
Which one of them relates to a fundamental right?
Pardon me?
Which one of them relates to a fundamental right?
I beg your lordship.
Which one of these relates to a fundamental right?
The right to marry.
No.
Fundamental right.
You see, when you're giving these examples, A, B, C, D, E,
Yes.
none of them actually relate to a fundamental right.
No, I'm not saying that.
Dunkerley or
I'm saying what's the law declared by Supreme Court. Lord, I'm going to come to derivative rights and enumerated rights a bit later.
Yes.
Lord, I'll get your lordship's point. I'm going to come to that later. What's an enumerated right and what's a derivative right? What is the status of a derivative right? I'm going to put that proposition. But all I'm saying is, when you say fundamental right to marry, proposition 1 is it meant marriage in the sense of cohabitation, in the sense of peaceful union. And secondly, once the court says there's a right to marry, That becomes the law. Future legislation will have to take that into account. It can't transgress that unless that judgment is set aside. Now, please come to the next proposition. Well, I'm going a bit fast, if your lordship.
No.
Prohibits debate in parliament.
Pardon me?
Prohibits debates in parliament.
Yes, as learned solicitor says, that also prohibits a debate in parliament. Once the lordship has said there's a right to marry, parliament cannot then debate that there is no right to marry. We are going to. I'm just making the proposition.
Yes.
What's the meaning of a law declared by parliament? And when you say fundamental right to marry, what it means? Now come to Special Marriage Act. Now, if a lordship comes to the prayers in the writ petition, in my compilation, at page 117, there are totally 20 writ petitions. And when we decide this list, the writ petition, we must also bear in mind what are the prayers. And my colleague Mr. Amanja has taken the trouble. Please come to page 117.
Of your compilation.
Compilation, yes. Lordship's got it?
Yes.
Page 117. Now, just to save your lordship's time, there are totally, from page 117 to page 125. Now, Lord, this is Kaul has got it.
Just getting it.
Index to come. I'm sorry, but I'll just wait. I'll just wait. But out of 20 writ petitions,
Yes.
12, my Lord Justice Kaul has got it.
Yes.
Yes. 12 directly challenge various provisions of the Special Marriage Act. Some section 4, 7, 8, 9 schedules. Some want to declare the entire law invalid. Then, my Lord, I'll just make a note. Lordship will just kindly note. 117 to 125 are challenges to SMA. 125 to 128 are challenges to SMA plus some other act.
How many in number?
Total 20 writ petitions.
No, 125.
Yes. Now, if your lordship wants, only SMA 12 writ petitions.
Yes.
Then SMA plus other acts are 13, 14, 15, 3 writ petitions. 13, 14, 15. Then, my Lord, only Hindu Marriage Act are 16, 17, 18, 3 writ petitions. Foreign Marriage Act, 1 writ petition. Citizenship Act, 1 writ petition. My Lord, I've just summarized, we have summarized to the extent possible what are the grounds of challenge. So now I come on, sorry.
Yes.
So, my Lord, this table will give your lordship what are the cases before your lordship, what have they challenged, what grounds they have challenged.